Yes, that's what I was. Okay, so I'm Bozo.
Oh,
Yeah.
I used to live in Edgewood.
And I it was so funny because normally
last midlife crisis years ago was it? So I wasn't ready to leave.
I'd like to begin with the roll call. That's right, I think it's I like this, okay, Anita. Here. Colleen. Here. All right, we have a quorum. Okay, so I would go ahead, I would like to entertain a motion to open the hearing on case number 24 TOEB 1 project versus Brian Evans. Do you have a motion?
So motion.
For a second?
I second.
All in favor? Aye. Motion carried.
Aye.
Okay. Let's go now. Consider case number 24 TOEB 1. First, I would like to add one board exhibit for the record. The rules of the procedure adopted by the board will be marked as exhibit 17. I'd like to ask for a motion to enter these documents in the record.
Motion.
Can we confirm that they are? Exactly, is it the caucus rules?
These are the version that were signed.
Oh,
I just-
the rules for us.
Yes,
Our rules.
yes. I just didn't have them when we
Got it.
introduced all the exhibits last time.
Do you need a second? Is that where we're at?
Yes.
I'll second it.
All in favor?
Yes.
Motion carries. Okay. Motion, I would ask council if they have any objections. Documents that was 17. I would ask the council if they have any objection. They already voted, I'm not sure if that was. Okay, we are here today for a hearing on the merits of the objector's petition. We ask that the parties limit their arguments to 1/2 hour each. Mr. Morton, on behalf of the objector, this is your case. You may proceed.
Thank you very much. I have a question. Is there going to be any introduction of evidence?
You have 30 minutes to do whatever you want to do. in support of your
Including
case.
argument? I object to that. I'd ask for a little bit more time. I was, depending on argument, I may present some evidence. And I'd like additional time in order to present the evidence. I don't think my argument will take half an hour, but I would like some time to introduce evidence.
I think it's more so just if we can just kind of keep it.
Do my best.
We're not gonna go to 30 minutes, you're done for anyone, right?
Fair enough.
This is your time.
Okay, if I may begin. Thank you all. Just to begin here with before we get into each of the 3 objections contained within our objector's petition, I think it does make sense to start out by putting things into evidence. Starting with the affidavit of voters attending Township caucus, which has been received by the candidates. Do you have any objection to entering this? So if we can enter this into the record.
I will, but actually I do have an objection. I object to on the grounds of relevance. The board has no authority, jurisdiction whatsoever to consider what happened at the caucus. All this board has jurisdiction to do pursuant to section 10-10 of the election code is to consider the papers that have been filed and whether or not they're genuine, whether or not they're filed timely, whether or not they're in order, etc. This board does not have jurisdiction, however, to consider the rules of the caucus, what went on at the caucus, things like that. We start getting in then to some constitutional issues and interpretation of statutes, and that is not what this board is allowed to do. That's specifically reserved for the courts, and for those reasons, I object to the admission of the voters' affidavit.
So we can reserve a ruling on the admissibility of these until you hear the full argument. So that's what I would recommend. I'll number it, but you can vote when you vote on the objection, whether or not to introduce the evidence.
Right, but we shouldn't even be talking about the caucus if we have no
Right, but he's gonna argue why you have jurisdiction, he's gonna argue why you shouldn't, and I think you should let them do the full argument on that before you rule on a piece of evidence.
And we will get to that. Other piece of evidence that we are submitting is the Facebook post from December 1st from the Wheatland Township Republican Organization, which was also attached to our petition. So it's already separately part of the objector's petition, but as its own exhibit, I think it should be entered in.
So I'm not gonna entertain a motion to accept these into the record until after your argument, but I will number them and have them available for the board.
And for the record, I would state the same objections I did to the prior exhibit of voters affidavit. The board does not have jurisdiction to hear anything related to the caucus. It's all related to the filing.
Could you repeat, that's found in,
Section
You're saying this-
10-10 of the election code. So it's 10 ILCS 5/10-10. It lays out the procedures and the jurisdiction of the electoral board. And it very specific, the electoral board is a creature of statute, and therefore it can only do what has been given to it in terms of the powers provided by the statute. The statute is very clear. It says what this board can talk about. It does not say in the statute that this board can look at the caucus rules. Doesn't say that this board can look at the rules that parties follow in nominating the candidates. It's very specific in its language. And if you'd like, I can read that language to you or provide you a copy. Well, like my copy is not open. What the statute says, the electoral board shall take up the question as to whether or not the certificate of nomination or nomination papers or petitions are in proper form, and whether or not they were filed within the time and under the conditions required by law, and whether or not they are the genuine certificate of nomination or nomination papers or petitions which they purport to be, and whether or not in the case of the certificate of nomination in question, it represents accurately the decision of the caucus or convention issuing it, and in general shall decide whether or not the certificate of nomination or nominating papers or petitions on file are valid, or whether the objections thereto should be sustained.
so out of curiosity, if it isn't us, who would make a ruling on that?
That would be something for the courts of this state. Someone would have to bring an action stating that the rules of the caucus somehow violated a constitutional right of theirs, that the rules of procedure were improper, something like that. But that would be something that would have to be filed with the courts.
All right, thank you.
The allegation of the objector's petition is that the caucus procedures invalidated the certificate of nomination that was filed. Therefore, the allegation is that the certificate of nomination is not valid, which is one of the things he just listed to you in section 10-10.1 that this board does have jurisdiction to consider. In general, shall decide whether or not the certificate of nomination or nominating petitions, papers or petitions on file are valid. Whether the caucus procedures were valid to get us to that point reflects on whether the certificate of nomination itself is valid. And that's why you do have jurisdiction to hear this case.
And may I counsel with Mr. Morton also.
I object. This is improper. You're getting one counsel to represent the same objector.
Is there
I'm not aware
is there a prohibition that?
Do you have an appearance on file?
My firm does.
Well, I object. Go ahead.
There are multitude,
Would you state your name?
Matthew Welch. There are a multitude of appellate court cases that review through the electoral board process, the rules that were implemented during a caucus. As an example, Lenahan v. Township Officers Electoral Board of Schaumburg Township, 2013. Elect first 130619. Review the procedures of the caucus. Ferguson v. Ryan, 251 Elect third 1042, 1993, a third district case. Hacker v. Haley, 2021 Elect second 210050, 2021. All of these involved an electoral board reviewing what occurred at caucuses, rules, etc. You can ask your counsel. I litigated with your counsel involving electoral boards that reviewed the procedures and rules of a caucus, Plume Township. I believe Mr. Mullen was counsel on one of these cases. Hacker v. Howard. So I assert that opposing counsel's arguments have no basis in law. 10-11 or 10-10, sorry, as Mr. Morton said. You get to review if the petitions are valid and whether they were filed under the conditions as required by law. Were these filed under the conditions as required by law? Was there a proper caucus? I just gave 3 appellate cases that where electoral boards as well as the courts reviewed what occurred at the caucus. I believe his argument should be denied.
Could you gentlemen say, like, why wouldn't Mr. Pajan go the other route? Why wouldn't he take it to like a higher court?
The election code allows it to come before the electoral board. We're following the procedures of objecting to petitions if we believe they are not valid, which that's why the objector brought it here during the time required.
Right here, I'm reading here, but you sent me, and it's saying outside. That's why I was like, oh, I didn't,
What I sent you was Mr. Copeman's email
oh,
where
okay,
he was laying out his argument
well, in case.
in an
he's
email
there
that
as
he
well.
sent to me. I wanted to make sure you had that email. So that's just his argument, and this is the argument of the objector that responds to the argument that Mr. Copeman made in that email.
I'm saying this, you're putting out, I'm reading that there's other cases that would say differently, so it's, I guess, subjective, but these are actual rulings as well. That's what I'm saying. Okay, can you proceed?
If I may be heard or reply. For example, again, they're trying to pull the wool over your eyes, okay? They're not asking you to look at if there's some defect in the nomination papers. Okay, that's all they can ask you to look at, and the source of that defect, if you will. For example, the Lenahan case that Mr. Welch refers to, the allegation there was that the certificate of nomination by caucus was not valid because it wasn't signed by the township chairman. Okay, there was an acting township chairman, and then the court case. I don't know what happened before the electoral board, because the court case doesn't give us all the electoral board proceedings. But in the court case, they looked at whether and how they put in, they delved into that. But the ultimate conclusion was, wait a minute, that's what parties do. Parties can do, they can manage themselves. They can select their leaders the way they want. The question is whether or not the nomination, the certificate by nomination was valid because it was signed by the acting township chairman.
So it wasn't the
So-
caucus rule.
Correct. It had nothing to do
Right.
with the caucus rules.
Ferguson v. Ryan dealt with caucus rules.
And I'm not familiar with that case, and I'll be happy to reply to that if need be. I just need time to get a copy of it. But I'm telling
Well, if
you
we're
right
gonna do
now,
this, we all need copies of all of it, because, you know, you're speaking Greek to us, so can we make the argument and then we haven't put
well,
this into, we haven't put this into the record yet, and then.
it is in the record because it's being recorded.
We haven't voted.
I understand that.
If I may proceed with the argument. As an initial matter, one of the exhibits we presented here is the affidavit of participation in the caucus, and just to renew and append the motion from our previous session about disqualification of this board, we would point out that this affidavit is signed by 2 members of this board, having participated in the Republican caucus on December 3rd. That is Ms. Hart, excuse me, and
Mr. Akias.
Rockets, thank you. They both of their signatures appear on the Republican caucus, which speaks to the bias that we alleged in our prior motion. That's,
And you voted to adopt the rule.
and then would have voted to adopt the rules, correct? I'm sorry?
Well, I didn't say, but it doesn't matter. It's,
Our objector's petition is separated into three separate objections. The first is a deficiency in the way that the certificate of nomination by caucus identifies the governing body that this is being filed on behalf of, or for the election that is at issue here. If you look at the certificate of nomination by caucus, which is the board's exhibit 1, the nominating papers, it says, "We, the undersigned, do hereby certify that on December 3rd, 2024, at a caucus of the Republican Party in the city of Naperville in Will County, Illinois, the following nominations were made." It does not say that these nominations were made in Wheatland Township. It does not anywhere else within this document identify that any of the participants, any of the candidates, the presiding officer, the secretary, any of them were in Wheatland Township when this was filled out and signed and attested to. The only mention of Wheatland Township is that this is being filed with the Wheatland Township clerk at the top and the bottom. But it says that they are certifying the caucus results of a caucus that occurred in the city of Naperville.
I'll object. That's beyond the scope of the objection here, and they cannot amend their objection. He's arguing.
You can raise that in your response. I
But I want to make the record.
You can raise that in your response.
He's making it part of the record.
You can raise that in your response. Let's give both parties the opportunity to give their case uninterrupted.
Thank you. The statute at issue here is section 45-10 of the Township Code, which provides that the chairperson's political party shall not be permitted to nominate a candidate either by caucus as provided for in this section or as otherwise authorized by the election code in the next upcoming consolidated election for any office for which a nomination could have been made at the caucus should the chairperson of the Township Central Committee not have met the requirements of this section. The provisions that what that means is that provides a penalty, which means that the provisions of the Township Code here are mandatory. They're not simply directory. They're not just something that you should do, but it's all right if you don't. There are consequences to not following the Township Code as written. And what is provided for in the Township Code in this section specifically is that on the first Tuesday in December preceding the date of the regular township election, I'm quoting from 45-10A, a caucus shall be held by the voters of each established political party in a township to nominate its candidates for the various offices to be filled at the election. 45-10B states, the board shall fix a place within the township for holding the caucus for each established political party. And then the certificate of nomination by caucus needs to reflect where the caucus occurred and what it is attempting to nominate candidates for. The city of Naperville is its own political body. It has its own procedures for electing its officials. Naperville Township is its own separate body, its own separate political body just north of Wheatland Township. By placing city of Naperville here rather than the township of Wheatland, as the form indicates, if it's a township, city, village, or township, you put here. They did not put township, they put city of Naperville. They did not identify any of the candidates as having residence addresses within Wheatland Township, nor the presiding officer, nor the secretary. Because this is a mandatory provision to include Wheatland Township on the document being filed with Wheatland Township, there is a failure to abide by these mandatory provisions, and the consequence of that is that the slate of candidates cannot be printed on the ballot. That's the penalty provided in 45-10, because the chairman of the caucus submitting this form did not abide by the requirements. The second issue in the objector's petition is that the township assessor candidate, Bruce P. Dorada, failed to file the proof of qualifications. That is a requirement of section 45-30 of the Township Code. Allow me to read that for you. In 45-30, it states that nomination papers filed under this article on behalf of a candidate for the office of township or multi-township assessor are not valid unless the candidate named in the papers files with the township clerk or the Board of Election Commissioners, as the case may be, proof of the candidate's qualifications as provided in section 2-45 of the property tax code. They are not valid, the papers, unless the candidate file with the township clerk those qualifications.
Could you repeat, Mr. Morton? You
Sure.
said township clerk or, what was that?
The township clerk or the Board of Election Commissioners,
Thank you.
which does not exist here. And
So if they put it in the Board of Election, so it has to be a local board, so it couldn't be Springfield Board of Election?
correct, it's not the state board, it's the local board. It's not,
Does it say that? Just out of curiosity.
it states with the township clerk or the Board of Election Commissioners. As the case may be.
So,
I don't know.
the Board of Election Commissioners is a term of art. It's not just any election commissioners. The city of Chicago has in the statute a Board of Election Commissioners for the city of Chicago, where the commissioners are appointed by the chief judge of the circuit court. But it's a specific entity called the Board of Election Commissioners. It's not just a general term for election commissioners. So the township clerk is the election official for the township election, and there's not a Board of Election Commissioners that oversees
In the summer.
in this.
So that's what it is.
Correct.
So it references section 2-45 of the property tax code. If you look there, it states in subsection C, no person is eligible to file nomination papers or participate as a candidate in any caucus, a primary or general election, for or be appointed to fill vacancies in the office of township or multi-township assessor unless he or she possesses at least one of the qualifications listed here. So no person is eligible to file nomination papers unless they are qualified. In part, it continues then, actually, that was part C, excuse me, in part C, the candidate cannot file nominating papers or participate in candidate unless a copy of the certificate of his or her qualifications from the department is filed with the township clerk. Cannot file nominating papers unless it is filed with the township clerk. In exhibit 1, you can see there that the documents that the nominating papers that were filed did not include Bruce Serrata's qualifications, which is a violation of section 45-30 and as applicable then 2-45 of the property tax code.
No, I have a quick question on that. I've been meaning to ask you. And the Democrats didn't file one either. So does that mean we don't have assessor in the township? That
Well, no one object. So the way the statute reads, it says the nomination papers are deemed valid unless someone objects to them. So if no one objects, then a mistake is ignored. So let's say I'm running for office and I forget to file my statement of candidacy and no one objects, then it doesn't matter.
why would
So,
you? Why?
but then,
I'm like,
you know, if
there
there's-
isn't a candidate to run on the other side. So does this mean we're not going to have a?
that means there's a vacancy and there are procedures in the statute for filling a vacancy.
Except that there is not, if I may, for the Democrats, because they're.
You're referring to vacancy and nomination.
I'm just saying that there is a
Right,
candidate.
But,
But there isn't a candidate for the Democrats.
You said didn't file the certificate.
No, they don't. No,
Because there wasn't one.
There wasn't one, right?
Gotcha.
right, so no one, if there was, if there was no one running at all, after the election, there would be a vacancy, and there is a procedure in the code for filling a vacancy that the
Okay.
board would follow.
Then the last part of our objector's petition is regarding the qualifications to be a participant in the caucus. The eligibility requirements for participating in a caucus are laid out in section 45-50 of the Township Code. And they are the exclusive participation requirements. It specifically says in section A that no participant shall be able to participate or vote at any township or multi-township caucus if the person is or was at any time during the 12 months before the caucus, any of the following. And it lists the 4 things that you cannot have done for another established political party to be a qualified participant in the caucus. As it relates to this petition, number 4, so 45-50A 4, a voter who voted in the primary election of another statewide established political party different from the party holding the caucus. This only applies in the past 12 months. The Township Code does not concern itself with anything that happened prior to that 12-month period for your eligibility to participate in the caucus. 45-50 continues in subsection C. Individuals participating in an established political party, township, or multi-township caucus shall comply with each of the following. And then it lists, again, the requirements for being a participant in the caucus. Notably absent from the participants in either, from the qualifications in either subsection A or subsection C is a requirement that you have voted in any number of that established party's primaries prior to the past 12 months. And actually, there's not even a requirement in here to vote at the last primary within that month. You just couldn't have, or within that year, you just couldn't have voted in the opposing political parties. There is no requirement that you have voted in the last one of two, the last 2 of 3, or as applicable here, the last 3 of 4. Because in those township rules.
Can I ask you a
yes.
question? So as I read the code, it says you can't participate if you voted in the opposite party's primary prior,
In the year prior.
in the year prior. Does that mean that everyone who didn't do that is qualified?
If they also meet the other qualifications.
Right, so the statute said these people cannot participate. How does that mean that everyone else can participate?
If they meet the other requirements, then yes, they can participate because they've met the other qualifications of section 45-50. The issue here is that a township party at their caucus cannot adopt additional rules of qualification. There's no authority within the Constitution, within this statute, that would allow the township caucus to go beyond what is prescribed statutorily. And what occurred here, and I'm sorry, that was the only copy I had of the rules, if I could get
Of
that
what?
back. I handed the caucus rules
Can you
to.
give him the
I have a
rules
guy.
back?
Did I? Oh, I didn't.
You didn't hand me the caucus
Thank you.
rules, no.
They were in my hand, yeah. We would also submit this then, as evidence. I'll hold on to it right now.
I'd like to, for the record, make the same objection. This board does not have jurisdiction to make a rule or interpret the caucus rules pursuant to section 10-10 of the election code. It's beyond the purview. You do it, you're going to invalidate the entire decision.
And our response from before applies to that objection. Renew our response. On page 4 of these rules, which are the Wheatland Township Republican Central Committee, Republican Caucus, December 3rd, 2024 rules. On page 4, it lists participant qualifications. Number 1, for the purpose of the caucus, each elector who wishes to participate and vote in the caucus shall be registered pursuant to the election code of the state of Illinois. That's statutory. Be a registered voter within Wheatland Township. That's statutory. Sign an affidavit that he or she is a registered voter and affiliated with the Republican Party holding the caucus. Statutory. Not take part in the proceedings of any other established political party township caucus for the same election. Statutory. Voted 3 out of 4 Republican primary elections. That's completely contrived and created for these rules. It does not exist in the township code. It is not something that is within the authority of the Wheatland Township Republican Central Committee to add to the rules. And here's an example of why that is, or here's further explanation of why. In part B of 45-50, that's about the rules of procedure. These rules of procedure that were adopted. And what shall be added to those rules, or what can be added to those rules. It says the rules of procedure shall include the following. Number 3 is procedures by which qualified caucus participants determine, et cetera, et cetera. Number 8, other rules deemed necessary by the Central Committee at the time the rules are promulgated or by the majority of the qualified caucus participants when the rules are being considered at their meeting. The rules of procedure shall include rules regarding qualified caucus participants. But if those rules are also dictating who can be a qualified caucus participant, then how can the qualified caucus participants prepare those rules and vote on those rules if you're leaving people out? The point is that there is no way for the committee to decide who can be a qualified caucus participant beyond the statutory requirements. Everyone who meets the statutory requirements is allowed, has a right to come in and be heard on those rules, on the rules for how the caucus is going to proceed. That's why they are mentioned explicitly in the rules of procedure. You can't, there can be no rule, in fact. This rule was not adopted until after the caucus began. It would have been voted on by the caucus participants, deciding what the rules of participation would be, who would be qualified. And yet, otherwise qualified participants were prevented from coming in and being part of the caucus because of the rule that was then adopted and which had been advertised prior, stating that you had to be a candidate at 3 of the past 4 Republican primaries. Vote in the
Okay, you know
primaries.
what, I'm gonna say, I was just thinking, I've not been involved, which is ironic, but I just went in, like I said, I didn't really stay, it was the reason I had to see somebody real quick, not in this room, since 2016. And I can remember that talking with the attorney, that because there was a primary or whatever, that it was their local control of that. Like, there was certain rules that you had to apply. Again, I can't believe I'm saying this out loud because I do believe it in fact that we should not be adjudicating anything that of the caucus rules. That seems completely out of our realm here, but just making a point. I know precisely, and I wish I had that language because we were actually on your side. We're like, no, you have to follow, and we got completely overturned and said, no, it is under local control.
Who is a qualified participant is not under local control.
It was who can bet, now you can't do, you have like the times, and I know you can't like shut out people, but of going in and like, that was like back in the day when it was super long. There was probably 100 people in line. And I do remember that. And I do remember questioning it because I had thought the same. But again, irrelevant. I just wanted to make a point with that because I do believe this is out of our realm. Like, I don't think that we should be adjudicating this whatsoever, because I did
But
look
you're-
at that.
You're adjudicating statute. Qualified
this is the
participant
rules,
must
I think,
exist
this is.
prior to the adoption of the rules. It has to exist prior to the adoption of the rules. You cannot adopt, only qualified participants can adopt rules.
And like my
So if
question I
that's
did
the
earlier,
case, the rule,
was anyone turned away? Like, it's still like, that's where it just gets way too. And now we're doing affidavit, we're looking at people that were there and like, I'm like, this is out of. Let's just move on.
There's a duty of the electoral board to determine if that certificate of nomination by caucus is valid. And if participants who legally, statutory, constitutionally have a right to participate in the caucus did not participate in the caucus because of the caucus's chilling effect of putting out that Facebook post that we've submitted that states exactly what the rules state, that you have to have participated in 3 of 4 Republican
Okay, can we
primaries.
just go on because it is
This, I
actually right.
am going on. This is
Right.
part of my argument. The 3 of 4 Facebook posts would have stopped people from coming because they knew there was no reason to come to the caucus where they're going to be prevented from participating. So, from looking at that, looking at the certificate of nomination by caucus, that this is not actually a fair representation of what the will of the potential participants was at the caucus, because not everyone was allowed to come in. Statutorily, constitutionally, there should have been anyone who meets the qualifications of the statute allowed to participate in that caucus. The effect of this is, as alleged in the petition, the youngest voters who had no opportunity to participate in 3 primaries by virtue of their age were automatically removed from this, regardless of their own choices of whether they did or didn't participate in a Republican primary. They could not have, if they were born after November 7th, 2002, they could not have voted in more than 2 primaries. There just weren't more than 2 primaries in their lifetime that they were eligible to vote on. Those people were disenfranchised by this rule that was enforced prior to adoption by putting out that post, and like I said, a chilling effect to prevent people from even coming to the caucus, and then adopting the rule that was not allowed to codify the fact that those qualified participants could not be there. The effect of this is that the certificate of nomination by caucus is invalid, not just for that reason, but for the other reasons we stated as well. Give me just one moment.
So do you understand how we've addressed your question?
Yes, I do.
So there is a list of what you need to be qualified. That is a qualified participant. That qualified participant must exist prior to the adoption of the rules. Therefore, the rules cannot change what a qualified participant is.
Okay, so.
The responsive case.
Go ahead.
Okay. I have some evidence I'd like to introduce. We can go, it can be easier, it can be hard, I don't know, but what I would do, I will bring these one at a time and see what the response is. And then if I need to have testimony, I will have testimony. Is that okay? The first is, put it on. I don't want to be going through my arguments and trying to put in evidence at the same time. I don't think that's proper. So the first is, I was going to ask this board to take notice of the official election results found on the Will County Circuit Clerk's website for 2021 and 2023 for elections held in the city of Naperville. In 2021, the only office up for election in the city of Naperville was that for councilman. In 2023, the only offices up for election in the city of Naperville were mayor and council members. I would ask the board to take notice of that. I won't call it judicial notice because it isn't a judicial proceeding. However, I do have copies of that from the clerk's website that I would ask go into the record whether or not they be admitted into evidence. Any objection?
Are these?
Usually.
Okay, so these are both 20.
Yeah, I gave you 2 in case the board wanted to see one.
Okay, yeah, I just wanted to make sure I was numbering it correctly.
Gotcha. I also would like to ask,
So,
We would object to the relevance of it.
Sure.
Don't see the relevance of this to the argument made here that the certificate of nomination by caucus identifies the incorrect township. It doesn't identify Wheatland Township. The election results of the city of Naperville have no bearing on that.
well, as I'm sure your board council will acknowledge, when you start to look at nomination papers, there's plenty of case law out there that says that one of the things you look at is whether or not, if there was a mistake in it, or if they were improperly filled out. With respect to substantial compliance, you look to the question of whether or not there's any possibility for voter confusion. In this particular case, I intend to argue to you that there could be no confusion either with the clerk's office or with the voters as to who the candidate, what offices the candidates were running for. Part of my proofs is showing you what offices there are on the ballot in the city of Naperville, as well as in the township of Wheatland.
So I'm gonna pass the exhibits to the board if you'd like to look at it. Oh, okay, I didn't see that. So do you want to, do you want to vote on the admissibility of these documents now, or do you want to wait until the end like we did with?
Be consistent.
Okay.
Agreed.
Along the same lines, the Will County Clerk's Office publishes a directory online. It's a directory of public officials that have what are officials for any district that touches Will County. And I would like to ask this board to take notice of that publication and specifically what offices are listed for the city of Naperville and what offices are listed for Wheatland Township.
And we would object based on relevance for the same reason.
Well, no, because that actually was what my notes that I was just writing down, being that I am city of Naperville, and we don't have a supervisor, a clerk, or assessor, a highway commissioner, a collector, or trustee.
Naperville does though. The
We don't
Naperville
run for
Township,
any of that in the city of Naperville now.
but Naperville Township is Naperville, and they do have those positions.
It says Wheatland going across. And I also know, because I did, as you know, I like to do my homework and do a little digging, and they just had a case in front of the state's attorney, pretty much the same thing, and they said, look, you know what they're running for. So
What
let's
case was
just
that?
state, yeah, no, there was a case, it is what they, well, I will think of it, because I actually wrote it, because I did ask them about anything in that nature. Like, come on. Like that's, you know exactly what they're running for. It says Wheatland up on top and then it kind of goes down. And I would have this, no matter who was running, I would say that would be silly. Like, because there isn't, it says Wheatland Township up on the front and then it lists the supervisor, the highway, the going through. I mean, I just think I think that's what, and it's funny because that's what I have wrote down here. So let's move on. Go ahead, Brooke.
I have also, what I'd like to introduce into evidence are the affidavits of 6 individuals. Some of them are candidates, some of them are non-candidates, talking about their attendance. Again, I offer this may be an offer of proof, it may be for evidence. I do not believe this board has the right to review the caucus rules of procedure from the caucus on December 3. However, I do have affidavits from 6 people who were at that caucus. And the affidavits basically say who they are, where they live, that they live in the township, that they attended the caucus, that they did not. They personally had not voted in at least 3 of the last 4 primaries. It says how many primaries they have voted in out of the last 4. They state that that rule was not enforced, that they were not denied any right or ability to participate fully in the caucus. And they also state that they are aware of nobody who was denied the right or ability to participate in the caucus based on that 3 out of 4 rule. I would like to submit those to the board. Again, I don't believe this board has the right to be considering the issue, so I'm providing them now because I think this is the evidentiary portion. And if the board elects to go against the law and decide the issue on the caucus, this is my evidence against that and my quote unquote offer of proof for the appeal. So I'd like to submit these as evidence. With those,
Share them with.
I'm going to give you the original.
If you want, do you want to proffer these at this moment?
Yes, sir.
Okay.
And I also have copies, individual copies for the board. The first one is the affidavit of Thomas Brzezinski. Sorry. The second one is the affidavit of Bruce Dorada. The third one is the affidavit of Brian Evans. Fourth one is the affidavit of Michael Kraswinski. Fifth one is the affidavit of Juan Carlos Villamontes Jr. And I apologize, this is not stapled. And the last one is the affidavit, oh, I'm sorry. It's not here. The affidavit of Ruth Wiley.
We object to the submission of any of these affidavits. These evidences, they are hearsay. And specifically, the affidavit of Ruth Wiley and Juan Carlos Villamontes. Do you have the original as well?
I gave him the original.
Okay, because these are copies.
Correct. Well, everything I gave you was a copy.
Well, these are scanned copies. I'm just, do we have an original signature on the other two?
Yes, yes.
Thank you.
You're welcome to review.
The objection on basis of hearsay, though, these are out of court statements made by these individuals, and we would object to their being considered as evidence.
They
Right.
reference documents not part of the element.
I think it goes back to this whole thing that we shouldn't be adjudicating.
Correct. But I'm in a position where I have
Yeah,
to
because I
respond.
do.
All right, I'm gonna read, if I may, can I read
No,
a
okay,
passage
we
from
can-
Ferguson v. Ryan?
May,
You'll have a reply.
I'd like to respond to the objection. Mr. Morton says these are
Which objection
his objection to hearsay.
to hearsay?
Said hearsay. He said it's an out of court statement. We're not in court. Okay, we're in, this is an electoral board. It's a little less formal than a court proceeding. And it is recognized in your rules that the laws of the state and the laws of evidence will be generally adhered to, but there are reasons for allowing exceptions. And the reasons are, you're supposed to be quick, informal, or quick, formal, brief hearings. And to ask people to come here in the middle of the day when they have jobs and testify about the items in this affidavit could be a burden to them. That's why I'm asking that you accept these affidavits in lieu of their live testimony. And I believe, let's see here, Thomas is here. Ryan Evans is here. Is Michael here? Oh, I'm sorry, Michael Krasinski's here. So if you want to ask them questions, they're here, they can talk. And I offer that. So just wanted to make my record. Thank you. I'm still on.
Yeah, you're still on.
Okay, I'm gonna ask then at this time for one last thing. I have a document that was filed with the clerk's office on January 8th, 2025. I assume the clerk's office has the original here in this building. I'd ask the clerk to retrieve that if that's the case. But this is the statement or proof of Mr. Dorada's qualifications under the statute that qualify him to serve as an assessor. I only have one copy with me, and I would ask to submit this into evidence. That's it.
Do we have the original?
I need to see it, I don't know.
It was filed, please say.
It was filed January 8th.
Yeah,
I object with that evidence rule.
but I think we didn't have that, didn't we, from that came from? Nothing.
You also need to see this.
If the no objection is the best evidence rule, I'd ask the board to recess and allow the clerk to retrieve the original
And
document.
again, the allegation is not that he didn't have the qualification, it's that it wasn't submitted as part of the nomination
But
papers.
that's what I was just gonna ask, if it had to be submitted with them, or just, it has to just be some, they have to be submitted.
This was on the eighth.
Right.
Pardon me?
Excuse me.
We'll let them argue that and then
So
you can decide that.
is that in evidence or no?
It's up to the board to vote. Since they've taken everything else under advisement, I was just gonna.
That's evidence objection, but we don't think it's relevant. We're not saying that doesn't exist. We're saying it was allowed with the nomination.
Okay. Yeah, I definitely think Even though I'm so confused, because I thought it did have to come in with the packet, so.
All right, that's all I wanted to introduce by way of evidence. And now I want to address the arguments, and I'll take them in the same order that the petitioner presented. And first of all, there's an objection to the certificate of nomination by caucus, and you have the original up there. It should be, I believe, exhibit 1 was the nomination papers packet. You can look at it. On the objection, as I understood it before today, based on the objector's petition, was that it was improperly filled out because it refers to City of Naperville. There was no objection made prior to today that the caucus did not occur in Wheatland Township. Okay, so I would call any one of these candidates. In fact, I will. Todd, you want to come up here? Sure. I'd have to ask if Todd be sworn.
We were not able to get a court reporter in less than 24 hours, so.
The clerk can swear.
If the clerk is a notary, you're a notary, right?
No,
Okay.
You swear in?
Do I have some sort of script to swear him in? Or you whole truth, not nothing but the truth kind of thing? Sorry.
How about name, address?
Yeah. So, Anita, just
Yeah.
repeat after me.
it doesn't need to be Bill since he's the notary.
Okay. Ask the witness to raise his right hand.
Raise your right hand.
Ask him to swear or affirm that he will testify truthfully
Do you swear and affirm that you will testify truthfully?
Yes.
and remind the witness that he is under penalty of perjury.
And I'll remind you that you are under
Penalty of perjury. Penalty.
under penalty of perjury.
Okay.
Okay. Could you introduce yourself to the board, please?
My name is Todd Morris.
Where do you live, Todd?
I live at 23641 West Andrew Road in Plainfield, Illinois.
Are you familiar generally with the boundaries of Wheatland Township?
I am
Can you tell me what they are roughly?
roughly 83rd Street North, south to 135th Street, approximately the Bolingbrook Golf Course to Yola Road.
Do you live in Wheatland Township?
I do.
Do you own property in Wheatland Township?
I do.
And your property tax bill, does a portion of your taxes go to Wheatland Township?
Yes.
Did you attend the Wheatland Township Republican primary on December 3rd, 2024?
Yes.
Where was that held?
That was at,
You can't refer to anything.
okay.
What was the name of the place or,
It was at the corner of 104th and Napier Plainfield Road.
okay. And is that in Naperville?
Yes.
Is that in Wheatland Township?
Yes.
Were you present for the entire caucus?
Yes.
Were nominations made office by office or as a slate?
So it was made as a slate, but they asked if anybody else wanted to run for any of the offices.
How many slates were nominated?
One,
Was anybody else offered to run for any of those offices?
it was open to everybody that was,
I know, but was anybody else offered or up for that?
I would assume so, yes. Right?
You were there, correct?
It was, well, they agreed to elect the slate. That's what happened.
Let me back up. A slate was nominated, correct?
Oh, yes,
Okay, were any other slates nominated?
no,
Were any other persons offered or nominated to run for any of the offices against that slate in the caucus?
no,
Okay. Was there a vote on the slate?
yes,
Was the slate approved?
yes,
Were you present when the results of the caucus were announced?
Yes,
Who won?
the entire slate.
Okay. May I have the objectors or upside the nomination papers, please? Over here. Okay. You would take that document. First page is a certificate of nomination by caucus. You take a moment to review that, just the names that are listed there. And tell me do you agree that it says that Brian Evans was nominated for the office of supervisor, Robert Whittier for clerk, Bruce Dorada for assessor, Todd yourself for highway commissioner, Michael Wisniewski for tax collector, Michael Kraswinski for trustee, Randall Happ for trustee, Tomas Brzezinski for trustee, and David Furnish for trustee. Is
Yes,
that what it says?
yes,
Were those the results of the caucus?
yes,
So to the best of your understanding, is that certificate of nomination by caucus correct in terms of that's who was nominated by the caucus?
yes.
And then part of my proffer from earlier, prior to December 3, 2024. And that caucus, have you voted in 3 of the last 4 Republican primaries?
I believe so.
Did you, or strike that, are you aware of anybody who was prevented from entering, attending, or participating in the caucus who had not voted in 3 of the last 4 Republican primaries?
No, I think everybody that came in was allowed in.
I'm sorry, I do repeat that, I just I can't hear you.
Yeah, everybody that showed up was allowed in the door.
And then that's the end of that proffer. On January 2025, did you file anything with the township clerk's office?
Yes, our nomination papers were right.
No, on January 8th of 2025, did you file anything with the clerk's office?
Oh, with the clerk's office, yes.
What was that?
That was to review some surveillance.
No, I'm not asking for a FOIA. Did you file a document on January 8th, 2025 with the township clerk's
Oh,
office?
yeah, that was for the qualifications.
Those are Mr. Dorada's qualifications?
Yes.
Okay. He asked you to take a look. Is that a fair, accurate, and complete copy of the document you filed with the township clerk's office on January 2025?
Yes.
That's all the questions I have. Thank you.
You'd stay?
Sure.
Do you have a copy? We,
Original on that?
do you remember the Wheatland Township Republican Organization?
No.
You're not? I just handed you a document. Can you state what that is?
It says Wheatland Township Republican Caucus.
What is the date that this was issued?
What does it say on the form?
Sorry, yeah, the date.
December
What date is
1st.
on the form?
It's printed this December 1st, so it looks like a website. maybe.
Okay. And you testified earlier that you attended the caucus, the Republican caucus for Wheatland Township, correct?
Correct.
What date was that caucus on?
Drawing a blank on the date right now.
If I were to give you a document that would refresh your memory.
December 3rd.
December 3rd?
Yeah.
Okay. Can you read that first sentence on the document that I handed you?
It's already been repeated. Yes, if you live in Wheatland Township and voted in 2 out of 3 primary elections, you may attend the caucus on Tuesday.
Do you know the facts and circumstances that caused this statement to be made?
I do not.
You do not? What is your interpretation in reading that sentence?
What it says.
What
It just says.
I'm asking what your interpretation is.
What it says is if you didn't vote in 3 out of 4 elections, you may attend the caucus.
If
You may attend the
If
caucus.
you have voted, correct?
I have voted.
No, the statements, if you have voted, 3 out of 4, correct?
Says you may attend the Congress, yes.
So if you haven't, it's reasonable to assume you're ineligible to attend, correct?
It would be someone's interpretation, yeah.
Okay. And you have no personal knowledge as to who caused this to be issued?
They do not.
You do not? And what was it issued? What social media vehicle does the document purport be from? Do you recognize this?
Facebook.
Okay. No further questions.
So, thank you. So the certificate of nomination caucus, or I'm sorry, certificate of nomination by caucus that the objectors objected to. The only thing, like I said prior today, that I understood they were objecting to was use of the word city of Naperville. They had not objected to or claimed that the caucus occurred outside of the township. That was my objection to Mr. Morton's arguments earlier. He was suggesting that the caucus had not occurred in the township of Wheatland. Mr. Morris's testimony clearly establishes that it occurred in the township of Wheatland, and no evidence has been offered to contradict that.
So we'll clarify, if that was he conveyed that message, that was our argument. It is not the argument. So we waive any issue related to allegations that the caucus didn't occur in Wheatland Township.
Thank you. By acceptance of the filing, which is exhibit 1 with the board, the clerk's office has implicitly understood exactly what these candidates were trying to do. They were trying to file their nominations and to run as candidates for township offices, plain and simple. If the clerk's office did not believe that documentation was to run for township office, then they should not have and could not have legally accepted that. They should have, if they thought it was for the city of Naperville or any other organization, should have directed the individual to go file in that place. They're not to accept filings for other offices in the township.
Can I just ask you a question?
No, you can ask a question. You don't respond.
It's only a question. It's
Okay,
only-
but don't
well, I'm
respond
not-
in your role as the clerk, but
I'm asking, the question I'm asking is, are you suggesting it is the office of the clerk's responsibility to prove the documents that are submitted for filing?
I assume, no, strike that. The clerk's office should review what is filed. Do you not give a receipt to everybody who brings in the paperwork? You have to provide, do you provide the filing party with a receipt?
Yes, but I'm not supposed to be asked. I can't talk as clerk, you can't ask me as clerk, but my question is to you, are you suggesting that it is the responsibility of the clerk in this office to prove all the documents that are submitted and, edit or make suggestions for improvement? Like, what are you saying?
What I'm saying
Could have
is,
happened.
you have a duty to look at the document to make sure that it was being filed and note what was being
I
filed.
think the clerk has a duty to confirm that a document has been filed. I don't think it's their responsibility, but I'm asking you, is it the clerk's responsibility to prove every document that they are asked to file for the?
If someone came in here to file a deed, would you accept that?
Well, we don't do deeds, so
Correct.
probably no,
Right.
but
Would you accept
you're now,
nomination
again,
papers?
I was just instructed not to respond as clerk, so I'm asking you, so stop asking me.
I'm giving you.
Are you suggesting it's the clerk's responsibility to prove documents that are submitted? That's what I'm
To
asking. Should we?
prove
It seems we're getting close that her testimony may be required, and we may have to reconstruct this electoral board under Jerome McKee.
I think you're just asking for you to go. I do know, like when I was Naperville Park Board and people would try like, oh, do we have to submit our papers into the park board or do we have to put them into the council or, over at City Hall? Or do you have, and people always try coming in and they're like, we don't take these. But I also know the situation in Oswego where they did. So I think it's just,
I would point out, your duties are set by statute. nowhere does it state the municipal code or the election code or any code, township code, that the clerk is responsible to review and comment on nomination papers. There are, as everyone in here knows, extensive litigation related to the filing of nomination papers, and there's not one case that said, well, because the clerk didn't identify the problem, you're okay.
That is my question.
Yeah, no, I actually agree. That's why
I was not suggesting that you had to prove
Or to work.
no, I did not suggest that the clerk's office needs to prove all documents that are filed. What I was suggesting was if the clerk's office knew that the paperwork was not intended for the township, it should not be here. The clerk's office
But
would
that's
not
what we didn't
have
ask, and that's what we're
accepted.
not gonna go today, right? So, again, you answered my question. So you did actually.
And just like council stated that nowhere in the election code or the township code or in any case law, nowhere does it state what this form is supposed to look like. Nowhere does it state exactly how it's supposed to be, what form it's supposed to be in, which is interesting. Because in the election code, and council will admit this, Article 7 and Article 10, it lays out specifically certain things you gotta have when you're looking for a petition, when you're looking at a statement of candidacy. It says specifically, it prescribes the form. It tells you exactly what it is. Nowhere is this form prescribed. Okay? Now, counsel in his argument said that section 45-10, it's mandatory. You gotta follow it. If you don't, then the Republican Party can't put up a slate of candidates. The problem is he's reading only section 45-10. Okay? And if I may approach. Ooh. This is a printout from ILCS. I just want to show you that we're talking about section 45-10 right here. Right above it, it says Article 45. Nomination of candidates for township office, okay, Article 45, and then there's section 45-10. Then after that, there's section 45-15, and 45-20, and on, okay? What he pointed to is he says, if the chairperson of the Township Central Committee fails to meet within the township, or to meet any of the other requirements of this section, the chairperson's political party shall not be permitted to nominate a candidate. This document is certification of nomination by caucus, which is not prescribed anywhere in the statutes. No. But section 45-20, the next section, it says the chairman of the Township Central Committee shall file nomination papers. The nomination papers shall consist of 1, a certification by the chairman of the names of all candidates for the office in the township nominated at the caucus, and 2, a statement of candidacy by each candidate. That's what this does. This certificate sets out who is nominated for each office in the township. Supervisor, clerk, assessor, highway commissioner, tax collector, and 4 trustee candidates. It lays it all out right there. And what he read, Mr. Morton stated that the statute says you have to say where the caucus occurred. It doesn't say that in there. And he can't point to any statute that says you have to say in the nomination by certification of nomination by caucus where the caucus occurred. Okay, but they did. They said where it occurred. It occurred in the city of Naperville. There are portions of the city of Naperville that are in Wheatland Township. Mr. Morris testified that where the caucus was held was in Wheatland Township. So again, they haven't alleged that the caucus didn't occur in the township. And 45-10, if it hadn't, we wouldn't be here. I'd be done. They win. But it did happen. It did happen in Wheatland Township. So they have not only substantially complied with the law, they completely complied with the law as it relates to the certification of nomination by caucus. As to the city of Naperville, Second. And, the other thing I would like to point out is there's a well-recognized case of Lewis versus Dunn. Lewis versus Dunn says, if there's any confusion as to what office is being applied for, you look at two things. You look at number one, well, no, you look at the entire filing, all the nomination papers. Okay, you look at whether or not there's a consistency within the nomination papers. There's no inconsistency between the certification of nomination by caucus and the statements of candidacy. When you look at them all together, you can clearly tell that these candidates are running for township office, supervisor, clerk, assessor, highway commissioner, trustee, tax collector. There's no confusion whatsoever. And if you want to continue down that path of confusion, the exploring whether there is any, you have to look at, well, what other offices are up in the area? Well, as we have testimony, parts of city of Naperville are in this township. The only place where anybody could claim any confusion within Wheatland Township are only those areas that include the city of Naperville. So when you look at the ballot for that area, what would be on the ballot? It would be the Wheatland Township offices, supervisor, assessor, tax collector, highway commissioner, court, trustees, okay? And the only other thing that could be on there would be city of Naperville. And what do we have in city of Naperville? Mayors, councilmen, council members. That's those documents I presented and had asked that you take notice of from the Will County Clerk's office. There's no doubt that there's only one supervisor office, one clerk's office, one tax collector's office, one highway commissioner's office, one assessor's office, and 4 seats for trustee. That's all there is. And there's no question where they are. They're Wheatland Township. There's no confusion. Also, of significant note is that the objector has not made any claims of fraud or mistake or confusion, fraud or mistake. Hasn't said that the nominee or certification of nomination by caucus isn't what it purports to be, or states the wrong candidates, or misidentifies who is actually nominated by the caucus. Mr. Morse testified to that. So the public policy of Illinois is one that favors ballot access and favors the finding of boards that candidates stay on the ballot because the people deserve the choice. And referring to Mr. Welch's favorite case of Lenahan, in that case, the court rejected the electoral board's decision because the electoral board's decision would have the effect, quote, to deprive voters who participated in the Schaumburg Township Democratic Caucus and those who did not but wish to vote in April for those candidates of their right to nominate and vote for the candidates of their choice. The certification of nomination by caucus fully complies with the statute, is not confusing, and this business about because it says the city of Naperville, read it. It says that the caucus took place in the city of Naperville. Okay, yeah, it happened in the city of Naperville, in the part of the city of Naperville that's in Wheatland Township. As to Mr. Dorada's qualifications, that's a point I'd like to address next. The objector has not pointed to any specific provision in the code which puts a deadline or a timeline for the filing of that qualification. If you look at sections 45-30, yeah, it says the nomination papers filed are not valid unless the candidate named in the papers files with the township clerk proof of the candidate's qualifications. But you know what section 45-50 does? It puts an onus on the clerk. It says, in the case of candidates for the office of township assessor, the township clerk shall notify the candidate of the obligation to file proof of their qualifications as provided in section 2-45 of the property tax code. They have not pointed to any provision that says you have to do it within a certain time frame. It's been done. the qualifications have been filed with the clerk. There's no basis, no reason, no statute, no case law that they've cited to that says, well, if the audit, or I'm sorry, if the assessor candidate doesn't file by a certain date, then they need to be removed from the ballot. That law doesn't exist, therefore, Mr. Dorado should remain on the ballot. And then finally, with respect to the last part, with respect to the caucus rules, this board does not have authority or jurisdiction to make any interpretation, review, decide, provide comment on any issue related to those rules. They're clearly outside of this board's authority. And I'll read the statute to you. Section 10-10 provides that the electoral board shall take up the question as to whether or not the certificate of nomination or nomination papers or petitions are in proper form, and whether or not they were filed within the time and under the conditions required by law, and whether or not they are the genuine certificate of nomination or nomination papers or petitions which they purport to be, or whether or not, in the case of the certificate of nomination in question, represents accurately the decision of the caucus or convention issuing it, and in general shall decide whether or not the certificate of nomination or nominating papers or petitions on file are valid, or whether the objections thereto should be sustained. You're only tasked and you're only given the authority to look at the circumstances of the filing of those papers. You're not to look at how the caucus was held, what the rules of the caucus were, where or what the caucus had to say in terms of participation. That's not your role. That's the court's role. If they had an issue with it, they could have filed a lawsuit with the court. They haven't done that. Your job is only look at these papers and make sure that they're genuine, make sure that they comply with the law in terms of what they state and what they contain. And they do all of that. I'm going to quote from an Illinois Supreme Court case, Goodman versus Ward. And the cases are very clear on the limitation of electoral boards. They can only look at the nomination papers, okay? Electoral boards are limited to only reviewing the validity of the papers filed and nothing more, not the statutes, rules, or laws governing them. And that's, I refer you to Goodman versus Ward, which is an Illinois Supreme Court case, and Bryant versus Board of Election Commissioners. From the Bryant court, this was their thing. This was their statement. As a creature of statute, the election board possesses only those powers conferred upon it by law. Any power or authority it exercises must find its source within the law, pursuant to which it was created. Under section 10-10 of the election code, an electoral board scope of inquiry with respect to objections to nomination papers is limited to ascertaining whether those papers comply with the provisions of the election code governing such papers. Administrative agencies such as the electoral board have no authority to declare a statute unconstitutional or even to question its validity. In ruling as it did, the election board therefore clearly exceeded its authority. Any action or decision taken by an administrative agency in excess of or contrary to its authority is void. The electoral board has no authority to review the rules of the caucus. And therefore, that portion of the objection should be dismissed, not overruled. It should be dismissed. Now, if you choose not to follow the law and you want to interpret the rules of the caucus, then I would point out to you the Illinois courts have for a long time given great deference to political parties in their own rules and procedures. Constitutional rights to freedom of speech and freedom of association are important in what political parties do. As such, they've often deferred to the political party's own internal rules. And this is from Carla Sari versus Will County Officers Electoral Board. As a general rule, political parties are free to conduct business at their meetings in a manner that is consistent with that party's own internal rules and procedures. And then going back to Lenahan, which quoted a United States Supreme Court case, it is well settled that partisan political organizations enjoy freedom of association protected by the First and 14th Amendments. And by the way, this is why this question shouldn't be considered by you. I'm talking about the First and 14th Amendments, and no offense to any of you. You're not lawyers. You haven't gone to law school. You haven't taken constitutional law. You haven't been trained in it. That's why this is reserved for the courts. But I'll continue with the quote. Freedom of association also encompasses a political party's decisions about the identity of and the process for electing its leaders. The court held that the laws at issue directly implicated the associational rights of political parties and their members by limiting a political party's discretion in how to organize itself, conduct its affairs, and select its leaders. In addition to all of that, okay, the objector has failed to allege or prove that this particular rule was enforced at the caucus. They have alleged, or they have failed to allege or prove or show to this board any statute. They like to talk about statutes and cases. They have not shown you one statute, and they have not shown you one case that says you cannot have a rule that says that a participant has to have voted in at least 3 of the last 4 primary elections. Section 45-50, which was referred to by counsel, he only talked about a little bit about this section, but I mean, section 45-50, the title of that section is caucus procedures. Okay? Caucus procedures. Part B, or subpart B of that section says the rules of procedure shall include the following. And it lists a few things: time, location, stuff like that. But the last thing it says is that the rules of procedure shall include, it says other rules deemed necessary by the central committee at the time the rules are promulgated, or by the majority of the qualified caucus participants when the rules are being considered at their meeting. Now let's parse that out. Okay. Mr. Welch argued, well, they're qualified participants, and that happens right at the start of the caucus. But what he ignores is that the Township Central Committee, they make these rules before the caucus. That determines who the qualified caucus participants are. The Township Central Committee can make their own rules of procedure. And they adopt those, they make those rules and they adopt them before the caucus. And then at the caucus, those rules are reviewed and they can be changed or put into place and the caucus proceeds. Okay. So the qualified caucus participants are determined when the rules are adopted. And the rules are adopted before, or are put together. I'm sorry. The rules are put together before the caucus. That can determine who the qualified caucus attendees are. Nothing in the state statute says you can't impose the additional rule of the 3 out of 4 participation here. And in fact, it specifically allows rules in addition to what are contained in the statute. As I said, the objectors offered no proof that that rule was enforced. They have not offered any proof that an individual was refused entry into the caucus, not allowed to participate in the caucus, not allowed to attend the caucus by enforcement of this rule. And in fact, we presented evidence that shows that many people who didn't meet this rule were allowed to enter, attend, and participate in the caucus. Based on all of that, I know it was a lot. I appreciate your time and your patience with me and hearing me out. I think it's pretty clear that the objector's petition in its entirety should be denied. I believe that the third objection should be dismissed, but the entire thing should be denied and overruled. And the names of all of the candidates who are named as respondents in this matter, except for Mike Wisniewski, who's withdrawn, I think everybody else, their names should be ordered by this board to remain on repute on the ballot. I'm happy to entertain any questions you have, but thank you.
I do have a question. Can you make a comment? The one thing, and I know I've my homework on this, the certification that was brought in. I thought I did, like for the assessor. That was my sticking point, because I'm like, it said, I thought I had read that they had to, that in fact. Have that included with the packet.
That I do not find any statute that specifically says that. They say it has to be filed. It says that the
Is there, I
filing.
mean,
Yes, I cited it actually in my argument. It is, I'll give you the citation again. It's 35 ILCS 200/60. No. 35 ILCS 200/2-45C.
how am I writing that? I did see it.
The candidate cannot file nominating papers unless a copy of the certificate of his qualifications is filed with the township clerk. So the filing of nomination papers came first, and then 3 weeks later, then they put in their qualifications. In addition, in the township code 60 ILCS 1/45-30, it states that nomination papers are not valid unless the candidate filed with the township clerk the qualifications. So there are two sections that both explicitly state that the filing has to be at the same time as the qualifications.
I think that's but
What was the second section that you quoted from?
60 ILCS 1/45-30. B.
The provision I was referring to was 60 ILCS 1/45-40A. And it says, in the case of candidates for the office of township assessor, the township clerk shall notify the candidates of the obligation to file proof of their qualifications as provided in section 2-45 of the property code. How could the clerk ever provide such notice if they don't know who the candidate is? Tell me that. I mean, that makes no sense. There's no statute that says you have to file it within this time frame. And that we've just shown you an inconsistency in the statutes. One says you have to file it before you can even file your paperwork. If you take that to its logical conclusion, that means Mr. Dorado would have to walk in here and file that piece of paper with his qualifications, and then they would file his nomination papers. This
I
statute,
mean, at the same time.
no, it says it has to be before. You can't file the
It says
nomination
before?
It
papers.
says cannot file nominating papers unless a copy is filed with the township clerk.
Right, so it would have to be filed with the clerk before you can file the nomination papers.
Together. I don't understand where you're.
Common practice has always been to file it contemporaneously with your nomination papers.
So are you're done and you're about to begin your 5?
Yes.
Okay, can we take a 5-minute break?
Sure.
Okay.
Got it?
Yeah.
2.
Good answer, Bill.
Oh, really? Which one?
okay.
That's nice.
We're officially in
I'm sorry.
we're officially in a stoppage.
Yeah. We're pausing. Sorry.
Okay, let's say with this, as they go in as a slate, if. Say like with the assessor of not putting in the papers, and we say that, does that take out the whole slate or? does
No.
it-
If you say that the assessor did not file their qualifications and is disqualified, the assessor is disqualified and the rest of the slate is not offended.
Oh, Bill, yes, he said it's recording. I heard it say.
Yeah, he did say it's.
Okay, okay.
Actually, just tie up and reply. Okay. I'm just gonna handle the jurisdictional issue, Brian, and everything else. Okay? You're absolutely right, that electoral boards have to find their authority in statute. In this case, they have authority pursuant to 10-10. Like electoral board shall take up questions as to whether nomination papers were filed under the conditions required by law. Proper caucus. Also, whether the certificate of nomination in question represents accurately the decision of the caucus. What we're raising here, the caucus was undermined, that the Republican organization advertised and eliminated potential participants by stating you have to do this to participate. Ferguson v. Ryan, as far as the authority of an electoral board, I know you don't have this case, but I'm going to read it just as opposing counsel did. They're reviewing a decision of the electoral board that found the procedures of the township caucus to be adequate. Trial court affirmed the electoral board's decision, and the appellate court affirmed the appellate court's decision. And just to illustrate that the appellate court felt it was proper to review the procedures of the caucus. Said, we note that the procedures used at the caucus to verify the eligibility of participants complied with the Township Act. The statute sets out the eligibility requirements for participation in the caucus. I'll point out the statute sets out, not the rules. Here, the voters were required to sign affidavits stating that they were eligible to participate. The affidavit specifically stated the statutory eligibility requirements. We find this was sufficient compliance with the statute's requirements. So if you buy opposing counsel's argument that there's no jurisdiction, they shouldn't be discussing this at all. The procedures at the caucus and eligibility requirements. He's saying that it's not your purview, but Ferguson v. Ryan.
Okay, so you're saying, so you're actually giving of a case, so that is enough of an opinion and how you're interpreting the law. Right, so
No.
that was like one case, so that's,
This is
so how we
this is a
interpret the
case-
law.
This is
Again, which-
a Joliet Township case.
yeah,
Or
that
Bob
a
Joliet.
judge.
Right,
Right.
an appellate court. So this is binding precedent. Okay. They were reviewing a decision of the electoral board that reviewed the procedures of a township caucus. Okay. The electoral board reviewed the procedures used by this particular caucus and held that they complied with the act. Okay. Eligibility requirements. And the appellate court didn't say, why are you even considering this? You don't have authority. No, they
But then
agreed
there's
and
the
they
first
analyzed
issue.
it.
The first issue, which then how you're reading and interpreting of that having local control of your caucus rules. Even though I didn't get so into that when I read that, we should not be adjudicating that.
So this is dealing with eligibility requirements. This is what this is all circling around, right?
Right, but
How
if we're
the
looking
caucus,
at it,
how the caucus implemented its eligibility requirements. That's what this issue is. And Ferguson v. Ryan is reviewing an electoral board decision that reviewed eligibility requirements of a caucus. They're reviewing an electoral board decision that took up the question. The appellate court's opinion was not, hey, you should have never looked at this. We're throwing this out for lack of
but that's
jurisdiction.
their opinion, that's not.
It's the appellate court.
But then it could
We
go
are-
into another appellate
We are
court and they
all,
would rule
we
different.
are all bound by the appellate court. It's not, oh, that's just their opinion. You
So
are
you-
bound by the
That
appellate
same
court.
case would go in front of another appellate court and they would have the same conclusion?
Yes. Stare decisis. That means we must honor precedent of higher courts.
in that particular situation, but you, so that same case couldn't be in front of another appellate court and you have a different.
No appellate court has offered a different interpretation. You are bound by principles of stare decisis to follow appellate court precedent.
Did the appellate court maintain what the electoral board ruled?
In this case, they held that what the caucus did was compliant. They upheld the decision of the electoral board.
Mhm.
All I'm arguing about right here is jurisdiction.
Oh, okay.
That you have the authority to entertain these questions.
I
So,
still think that's public papers, but it's still nevertheless,
and
right,
I'll submit Ferguson v. Ryan, 251,
right,
Bill
which,
F.
okay,
3rd,
so if we did,
1042, which happens to be this district.
but it still doesn't, remove the fact of having the procedures and the vote. I lived through this in 2016. This I definitely know, and I did talk with their attorney, and I talked to both, on both sides of the aisle about it.
So this is an issue of what it means to be qualified participant, right? Qualified participant cannot be set by rules. It is set by statute. Because there was discussion, well, the committee can promulgate rules, right? And they can. But those rules are not binding until they're adopted by qualified participants. So qualified participants exist separate and apart from the rules. Otherwise, it can never be adopted. Rules can never be adopted, right? It's a chicken or the egg situation, right? So a qualified participant is set by statute. And the organization promulgated a rule, advertised that rule, blasted it out to the community, which undermined the participation of this caucus in direct conflict with applicable statute. The council says we haven't cited the statute. The Township Code, Article 45, lists what a qualified participant is. That's it. There's no additional qualifications, because if rules must be adopted by qualified participants. You can't change. The rules don't exist, yet qualified participants exist prior to the rules existing. Where does that qualified participant come from? It comes from statute.
Yeah, I had the same argument. Okay. We're behind.
On the other points that have been brought up, specifically turning their attention to the assessor candidate, Mr. Dorada. Again, we cited to the section that says the candidate cannot file nominating papers unless a copy of the certificate of his qualifications from the department is filed with the township clerk. That's repeated in the township code. I would also point to the statement of candidacy signed by Mr. Dorada, which is part of the board's exhibit 1, which states, this is sworn and signed by him, that I am legally qualified to hold such office, including being the holder of any license that may be an eligibility requirement for the office to which I seek the nomination. Indicating that it's something that needs to be present at the time the qualifications are filed. If you look at exhibit 25, which was proffered by the candidates, this is the certificate of educational qualifications. The filing date,
Talk about this.
yes, correct.
Commissioner,
The filing date of the certificate of nomination by caucus was December 16th, according to the certificate. That's when it was filed. The certification of educational qualifications was filed 3 weeks later on January 8th, 2025. Not only was it not at the same time, but if you read this certification, it says these educational requirements are described in section 2-45 of the property tax code. That's the statute we cited. This certification is valid from February 1st, 2024 through December 31st, 2024. He filed this 8 days after it was no longer valid. This certification was not valid at the time he filed it. Had he filed, which he didn't, with the certificate of nomination by caucus, the result would have been different. We wouldn't have objected if he had filed it as he was required to. When he did file it, he was no longer qualified per the terms of the document that was submitted. On the first issue, about the city of Naperville being put on the document, the importance here is that it was a failure to follow the, excuse me, just one second. The problem with the document is not that it alleges that it doesn't specify that the caucus didn't occur within Wheatland Township. The problem is that looking at this form, it doesn't identify Wheatland Township as the township in which these nominations are made, which is the requirement. It said that this is going to the Wheatland Township clerk. If the Naperville Township.
Okay, yeah, this one I find that as being, you know exactly, you're looking at it, it's Wheatland Township, it has the list, they're all in that
If-
becomes it, this stuff is, but yes.
If Naperville Township's candidates had erroneously submitted it to Wheatland Township clerk, but they put Wheatland Township clerk, you would reach the same conclusion. Well, it says Wheatland Township clerk, we have to accept these candidates because this is where they submitted it. Where they submitted it doesn't matter. The contents of the document, which says this is a caucus of the city of Naperville, that's where the error occurred, and that's where it did not comply with the requirements of the election code or township code. And then lastly, on the third issue, Mr. Welch has already addressed the main concerns there, not just the jurisdictional, but how it also applies to the effect of those rules being promulgated. Mr. Copeland pointed out that freedom of speech and association are important. I believe he was citing from a case when he said that, or alluding to a case rather. And that's what we're dealing with here. The freedom of speech and association of people in the community who would not have been able to participate in this caucus against the rules of the township code that says you don't need these extra qualifications. And you only have the ability that we give you in statute to set qualifications. By adding extra qualifications, they're stifling speech, stifling association, and not allowing these people to participate. That's all. Thank you.
Okay, so the case is now in your hands. There are three separate issues. I think it would make sense to do a separate motion on each of those three issues. If you have questions, if you have questions for council, if you have questions for me, if you want to discuss it among each other, you can do that, but it has to be in public because of the Open Meetings Act. You can't. So,
I just had someone raising their hand.
Do we have to admit all that stuff?
Do we have the agenda?
We have to admit all the items like the
well,
general.
that is up to you. I would recommend that you do a motion. You admit all of the documents that have been submitted and give them the weight and credibility that you want to give them, but at least put them in the record so that they're there for appeal. Someone want to make that motion?
I'd like to make a motion to include all of the documents that Mr. Morton and Mr. Copeland would like included into the record. If that makes sense.
Second that.
All in favor?
Yes.
Yes, motion carried.
So like I said, you can ask each other questions, you can talk amongst each other, you can ask me questions. You can ask the attorneys any more questions that you have. And then I would suggest that there be three motions. One motion to grant or deny the objection to the assessor's credential. One motion to grant or deny the objection based on the city of Naperville. And one motion to grant or deny the objection based on the allegations relating to the caucus rules. And then, we'll have to make a decision on whether the objection is overruled or denied on each of those.
We need an agenda for today, just there's more about the meeting.
Yeah, I just didn't know, weren't we supposed to have that really good? We don't do public comment till after we vote.
We don't do public comment until after.
After you make the decision, yes, we close the case, you make the decision, you vote, and then there's public comment. We don't want public comment to influence your decision.
Please, regarding the point one with the city of Naperville at the top of the certificate of nomination. Nomination by caucus. I think it's interesting how Mr. Copeland brought up that there isn't really like a statute as to how you have to present it. Made me think that's almost like an extraneous document. I don't know. Did you get that feeling or?
Well, it can't be extraneous if it has to be filed and timestamped and.
Okay.
So,
But I know what you're
you're
saying.
saying the form, he's saying the form.
The
of it.
forms, can I ask Mr. Copeland questions still or no?
You can, but
Right.
the law says that a certificate of nomination needs to be filed.
Filed,
But
okay.
his argument is that the law that says that doesn't say what is required to
format.
be in that form. So this particular form is a form that is created by the State Board of Elections. And it is not, I mean, the form does not come from the statute, but the State Board of Elections is the administrative agency that's tasked with interpreting the statute.
Is that from the State Board of Election? Because I know I have seen, right, they can still have, but I know. I was just signing councilmen and I'm like, how do you have different? How do you have different petitions? Same thing with county board, like they're like, oh, I did my own, I didn't take it from the packet at the county.
Right, and
But
people are welcome to do that with any document they want, but this indicates that it's a State Board of Elections form. And if you go to the Township Caucus Guidelines, there's a publication of the State Board of Elections called the Township Caucus Guidelines. And if you click the link on there, you get this form. So this form comes from the State Board of
right, and I
Elections.
do. So I know what you're saying, I just. Looking at, what they're.
Is this a fair question? Did the other party use the same form?
That's not before you. I don't know that, and
So no,
no one has
it's not a fair
introduced that to you. Yeah.
Okay.
I can see the confusion of city of Naperville being penned there. It's quite clear that they're running for Wheatland offices. Everyone there knew they were running for Wheatland offices. It concerns me that the voters would walk in on April 1st and have no choices. This clerical error isn't like drop dead, like, oh my God, they can't move forward for me. That's my opinion.
I'm a language person, so words, like, I get really hung up on words, so I'm struggling on this one a lot. I think the way this is written is all really confusing too. I don't know, I think for me, if you go back up, the fact that if I know that's for the position, that helps me. But
Right.
I do struggle with
And,
this.
and I get it,
do
because the caucus was in Naperville. It's like, literally, I mean,
struggle with that.
that,
No, I just complained about these. They don't make it very clear of how, I would like to see, after this, like to see the township be like, this is the form. And then do another side, right, and this kind of, right.
Do it.
Well, it's in the township too, like you were saying. That's why I said I saw two different ones. It's the same thing for county board and all of them where they'll have different, and the one thing that I did catch it, I learned something for hours of me like looking at it. I didn't realize, like what Mr. Colton was saying, that from the list of the positions, the highway supervisor, those from there on, that's what has to be perfect. It's kind of what was my like what I took from what Mr. Colton had said, from here down is what they were.
And I
looking
think
for.
also what he said was from there down is what made it clear that it couldn't be city of Naperville because of the
Positions,
I think.
right?
I don't think it's someone else.
based on everything I've heard and all the documents I've reviewed, I would like to make a motion that we deny this particular objection pertaining to the township candidates being removed.
I second.
Second the motion, the second call vote, please.
All in favor?
Yes.
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 Okay, so the motion to deny the objection to dismiss the certificate of nomination on the grounds of the city of Naperville rather than the township of Wheaton, that passes. So we've got the other two to discuss.
Okay.
The second one, I think,
The assessor?
the assessor, Mr. Durant. Oh, I'd like to make a motion. No,
No, we have to discuss it
first,
We have
right?
to discuss and then.
No motion yet.
We have to discuss it.
You can make a
I have
motion and
some-
then discuss the motion, or you can
I
discuss
just
and then
wanna
make a
talk for a
motion.
minute.
That's fine, I'm sorry.
I don't think that the clerk,
Pardon?
I don't think that the clerk should be put in a position to review, like, proofread everything, right? It's just,
Yeah, though I was talking about that as it related to the previous document.
No, it's not that proof. I
it's
just think-
accepting, it's an onslaught.
Well,
You've
then
got all
it
these
came
people
up,
coming
right.
to file documents and it's like, get it done.
To look to make sure everything's in.
For
This one
Dorado,
literally came late. It came
that's my
after.
hangup. Is,
And it's
It didn't come together. and
I-
it came late.
I gotta tell you, I did a lot of digging into townships and it does make it pretty crystal clear. That needs to be attached. I don't know if it fell out. That's not why we're up here, but it does have to be
And it doesn't
attached.
matter if it fell out, by the way.
Right, and so I do that, yeah, that was like. As I was going in and really looking at all of this, that was the one thing, there's little. Wiggle room on that, there's no. That it says you need to have that attached. It is bothersome that there isn't. A Democrat on the other side that is running, and it concerns me being a Wheatland resident, like, now what do we do? Why would we? But it is what it is, and. That was not there, and now finding out that, on top of it, it's expired.
in light of that, I make a motion to, grant the objectors. Questioning of Mr. Dorado.
A second. All in favor?
Aye,
Yes.
Motion carried. It's rules. It's sounded very familiar. Understand any of this, and I wish I had this guy when I was kind of going against it in 16, but it's still, it is what it is. I've talked to some pretty up there, and it's not conflicting. It is pretty much saying of a local control, and this one, again, where you're talking about the caucus vote, I do think it kind of takes us out of our preview of what we should be doing. But even if that wasn't the case, I still believe that it is local control of what you're doing, and the caucus, and how it's said, and hearing, there was no one denied, and I know we can look at that big picture like, oh, this could be suppression, they saw it and didn't come. And if there was, what would be a big deal is if, in fact, there was like opposing. Like if there was a whole nother slate, like if that went back in the controversial days, if that was the case, but if there was,
But there could be going forward.
they could be.
What we're considering.
Well, see, now that's the other thing too, which is interesting, and again, I haven't been involved in years. But those change, so it's not like that's going to stay as the caucus rules, like it's,
No, but the statute states, right?
the statute stays, right,
What
well,
the township was requiring, that's not.
yeah, but the
for us.
required, that's.
It's looser than what they adopted.
Right, there are certain things you have to have, and then there's things that have been, right,
Right.
Yeah,
why
that's
they're
restricted.
Further restricting from what the township requires, which is,
but there's still,
What-
and no
what-
one was not.
I don't know the legal word supersedes, overrides.
Right, no, I definitely. That one. No. Cause I've read,
Can't the appellate court just make this decision?
Well, there he did.
Mhm.
They have to review your decision.
our decision on them.
Yeah, no, that's,
My issue was,
and there
what
was,
makes it worse for me is it was on Facebook. If it would have just happened at their meeting, it would be less, I would think it was less of an issue, but if I would have read that on Facebook trying to decide if I were to go
I
or
couldn't
not.
even find it.
I'm not even on Facebook, so
I can't
there's a
I'm like
lot
that.
of people who aren't on Facebook.
But there's a lot of people who are,
Right,
True, that's true.
but it's not,
so it wouldn't have been your problem, it would have been mine, but so that's.
You
do you
wouldn't
want to make a
miss
motion?
much.
You just, let's,
You want a motion?
Um,
Oh,
I don't know. if
Can I
know
make a,
the-
I mean,
You can make a
make a
motion.
motion,
yeah, my motion is to deny
the objector.
the objections.
I'm going to write up a decision based on your rulings, and we need to come back and sign it, so
Today?
no, we're gonna have to come back. We'll just come back, we'll open the meeting, you'll sign it, and it'll be done in 5 minutes, but we'll have to do that next week, because I can't do that now. So what I'm just gonna ask is that the motion is clear on whether you're deciding this on jurisdiction or whether you're deciding it on the merits.
Oh, we can't say we're deciding on both?
You can do that, but the court that if someone reviews it, the law requires the decision to state the reasons for your decision. And unless I know which decision you're making, I can't.
Platter. You can't say we're. It's a combo.
Well, you can,
Can I say both? I can say both, right? I'm the chairman. We could,
There's no jurisdiction. There's no jurisdiction.
I'm gonna say both. That's
Where'd your motion that way?
the
So
emotion.
what is your
yeah.
motion exactly?
so you
Deny
move to,
for-
you move to
For
deny
that.
objector's petition or overrule objector's petition on the
Overrule.
grounds that you don't have jurisdiction to decide an issue
And if I
challenging, and if I did, you don't think there's enough evidence to
Correct.
I think there's proof that there weren't disenfranchised voters because everyone who showed up got to participate.
Yeah, except we don't know who didn't show up because they read the.
I haven't fun involved.
so you can make that
I
motion.
make that motion. Your motion that you just said.
I think I'm disagreeing twice with you, like so. Right, so how do we vote?
Um,
Do we vote, are we gonna vote once or twice?
It's
One.
one motion.
Well,
motion. I made the motion.
There's
Yeah, no,
because you're being forced. You may agree with one, but not the other.
You have a split vote on jurisdiction and merit.
Or you,
I'm just asking what am I voting on? Like,
Okay.
am I voting on?
We could
two
do the
things
caucus
separately, or am I
jurisdiction
doing it all at once?
that denied of that jurisdiction, and then, so you think we can do,
Said that you
Like, can
can't.
we vote on our own jurisdiction? Like, is that?
Yeah, I mean, you. It is probably cleaner for you to vote whether or not you have jurisdiction and then vote whether or not
okay.
the
so
caucus
the
rules were. The question, the thing that was, if you vote that you don't have jurisdiction,
Then why
Then
would
you're
why would
voting
you
that you
vote on
don't have
merit?
the jurisdiction to make the second motion.
Exactly.
However, courts often will say in election cases that they're gonna decide all of the issues because of the speed with which they go up on appeal. So
The caucus jurisdiction, I make a motion to deny.
Deny his motion.
Deny.
Oh, no.
no.
I thought I had the motion. Oh, she had the motion?
I'm talking.
No, your motion is to deny the
Didn't
objection
go to law school.
to the caucus rules because you don't have jurisdiction to
Yes.
do so.
I make a second.
So that's what you're saying we do have jurisdiction?
We don't.
You second that. Okay.
Deny that.
All in favor?
We should do a roll call.
Roll call.
Yes, I support that.
So no, I don't.
Okay. Yes.
I make a motion to deny the objector's case based, the objector's case for the caucus rules based on, if we had to say something about
Right.
this. Because I don't think we need to, but anyway, based on the merits of the case as well.
And I second. Oh, wait, we're doing roll call.
That's correct.
Okay,
Well, you have
Now
a second,
roll.
so now do a roll call.
okay, roll call. Enid,
So confusing, so I'm disagreeing, so no.
Colleen,
Yes,
yes.
Okay, and so just for this record, Colleen was a yes, Suzanne was a yes, and Anita was a no.
Correct.
Didn't state your names.
Sorry,
That's okay.
I thought y'all knew us by now.
All right, so now we should do a motion to recess.
Do we have to do public comment?
Well, we have to close the case,
Okay.
right? So motion to recess the case to another time, and then we'll do a motion to adjourn the
Do you have
meeting
to
at the
pick the
end.
time before I motion to recess to another time?
Yes, and so we can do that. Monday is Martin Luther King Day, and I believe by statute we can't do it on a holiday, so it would have to be Tuesday or Wednesday. And either of those days is fine with me. And it'll literally be 10 minutes.
Is there any way to do this like really early or really late? I keep taking days off.
It is fine to do that. I will not be here if you do that.
Or
So
can-
I will,
or
I
can I
will,
zoom
look,
in for this
I
one?
can, you have to sign it.
Oh, I
You have to sign it. So I can email the opinion, someone can print it out, and the three of you, if you want to do it at. You can do it whenever.
you can do what you're asking. Early or late.
Early actually is better.
Then in which case, I could do either of those days,
You said Wednesday,
Tuesday or Wednesday.
Tuesday or Wednesday? Wednesday would probably be better.
I'm gonna say early,
I
8:30 or 9.
I could do it
I-
as early as you
I can
want.
leave it earlier.
I prefer 8.
Oh, that's so would I.
Yeah.
Is that cool?
That's cool. Because he has to.
For the record, we'll accept service fee. Which, yeah, requirement that be mailed or personal.
So we can just email him the decision after the meeting and we don't have to send him the certified mail.
Same here. I got no problem with that. Thank you.
Okay,
Now I could motion to recess. I
you can motion to recess the case
Recess the case until 8
Wednesday at 8
AM
a.m.
on Wednesday, the 22nd.
Second. I second that.
All in favor?
Aye.
Right, motion carries.
Okay, no public comment.
Yes, public comment.
I do. It's Todd Morse. I think it's sad that the board didn't let us speak prior to hearing our cases. I just want to make the board aware that there were some FOIAs filed in the month of December, asking for all the FOIAs that were filed in the month of December. There were 4 that were filed. Only one FOIA came back having to do anything with the Democrat or Republican Party. That was done by Michael Wisniewski asking for their paperwork. So my question would be, how did the Democrat, our objector, get copies of all of our information to object to us if he didn't FOIA this from the township? How did he come down and get copies of this? It had to be FOIA. We should not even be hearing this case on the fact that he got the paperwork another way. But it all sits here in your hands at the township. So we should have objected to this before any of this even started. That's one. 2, the paperwork that the supervisor filed to object this whole process. I got a surveillance tape, which took forever to get, which I did ask on my FOIA to come in and observe. So I didn't need to be put off 12 days to get a hard copy. I actually came in the other day and just videotaped it right off the security system that was here. I didn't need to be put off for 12 days. I should have had that information before, so I could have made public comment prior to this. The supervisor walks in, pulls into the township parking lot at 3:27. At 3:31, he's still talking to the office administrator. At 3:32 is when he walks into Mr. Green's office right down the hallway. At 3:36, Mr. Green is making copies, and at 3:40, the supervisor leaves the building. So if we're gonna follow rules, he filed late. The office was closed at 3:30. Never should even have been able to have been filed in the first place. The timestamp machine. It's funny how the timestamp machine worked prior to paperwork getting filed, and it works now. After stuff was filed. So none of this should even be happening in the first place. It's my opinion. And I do have another for you, but that's for another day. So, thank you. Not so sure this is all heading in the right direction, but I think that needs to be noted and recorded, so if this goes any further, paperwork, you can FOIA it yourself, get the information. Thank you. Here.
I thought we talked about the timestamp. Any other comments? Harry's.
It's a real quick one. Please. Harry Benton. Live in Plainfield. In Wheatland Township. Don Morris had stated that it closes at 3:30. The original nominating petition is turned in at 3:35. He acknowledges the time, and therefore that petition was late, and we should never be here. Just want to put that on record.
Okay, if we're gonna put it on record. The person who filed the paperwork was here prior to that time. It was Mr. Green running around trying to figure out how to timestamp it. He couldn't get it to work, he said, at that point in time, which eventually it did. So it was a little snafu within the township office. If you pull up security cameras, you'll find that she was here before that time.
Is there any more public comment?
That's the point. Motion to
Yeah,
adjourn.
motion to adjourn.
Yes, second.
Please, second.
I will second that.
All in favor?
Yes.
Aye. Meeting